Hello, I'm Claud Regnard, and for the last 40 years I've worked in hospices and hospitals helping to care for people with life-threatening or life-limiting illness. I'm going to look at the Mental Capacity Act, which governs how we make decisions, both in people with capacity and in those who lack capacity. The MCA, as it's often called, covers England and Wales. There is an equivalent in Scotland, which is called the Adults with Incapacity Act. I'm going to look specifically at the MCA and look at two aspects. I'm going to look at capacity and best interests. Now, there are three guiding principles. First of all, it's important to think about capacity in all situations, but you have to start by assuming that an individual has capacity. Just because somebody looks or acts differently doesn't mean to say that they lack capacity. Secondly, capacity is specific to the decision being made. So you can have capacity for one decision, but not for another. Thirdly, best interest isn't somebody's opinion, it's not general guidance, but it's a checklist required by law. There are three principles that guide what we should do. Firstly, if there's no suspicion of an impairment or disturbance of the mind or the brain, and a decision is needed, then you must assume capacity. You must assume that the individual has the capacity to make their own decisions, in which case you should ask them for consent for the care or the treatment. Secondly, if you suspect that there is an impairment or disturbance of mind or brain and a decision is required, then you must test that individual's capacity for that specific decision. It's important to realize that you can't test capacity without a decision being needed. So you can't go to a group of individuals and say, well, we're going to just test your capacity randomly. That is not allowable. There must be a decision that is required for that individual. Also, if several decisions are needed, then capacity will need to be tested for each one. Finally, verbal agreement can be sufficient for simple things like a cup of tea, but it's very important to realize that just because somebody agrees or acquiesces to an element of care, that is not the same as consent. Thirdly, if it's clear that capacity is lacking for that decision, then you must follow the best interest checklist. Now, essentially, that's it as far as the Mental Capacity Act and capacity is concerned. Simple, isn't it? Unfortunately, many healthcare professionals are still not getting this right, so we need to look at this in a little more detail. Let's look at testing capacity. There are four key elements to this. Firstly, can the individual understand the information? Now, very importantly, this assumes that the information has been presented to them in a way that they can understand. So that is the responsibility of the healthcare professional. Secondly, can they remember the information at least long enough for them to be able to weigh it up? Thirdly, can they weigh up the information? Can they balance the pros and the cons, the advantages and disadvantages of what is being proposed? And finally, can they communicate their decision? Now, this also assumes that everything has been done to enable them to communicate. So you can see that the understanding of information and communicating are very much responsibility of the healthcare professionals in ensuring that that is done the right way. Now, if the answer is no to any one of these, then they lack capacity for that decision. And whether they have capacity or they lack capacity, it's very important that this test and the outcome of that test is documented in the individual's case record. Now, when it comes to best interests, this is something I sometimes wonder is the most abused phrase in clinical care, and we need to understand what best interest really means as far as the law, the Mental Capacity Act, is concerned. Best interest only applies to individuals who lack capacity. If you have capacity, none of this applies because you ask the individual. So it only applies to those who lack capacity. Best interest is not what any carer thinks is best. It's not what I think might be best for the individual, but it is a checklist required by law to estimate what the individual would have wanted if they had capacity. So now let's look at what is required. Now, this list of 9 points is the minimum required by the Mental Capacity Act. Now, you don't have to start jotting these down because I'm going to go through each one in more detail. There are all of these, and you just wonder how often this is not being followed. It's very important, and it's essential that both the capacity test and the details of any best interests are documented in the case record. As far as a court of law is concerned, if you haven't documented it, then you didn't do it. Now, we're very good at documenting examinations, investigations, treatment, and consent. We're not so good at documenting things like the decision process, the discussions, and the communication details, and we need to be doing that. So let's look at the checklist. Well, first of all, have we consulted other people? We are obliged by law to consult with at least one person who can speak for the individual. Now, this might be a partner, the parents, the legal guardian, relatives, another carer, health or social care professional, a health and welfare lasting power of attorney, LPA, or a court appointee. There are some rare occasions when there's no relative, legal guardian, or court appointee. And if time allows and the individual is age 16 years or over, then you can instruct an IMCA in England and Wales. That's an independent mental capacity advocate. I have to say, even when there is someone who can speak on behalf, sometimes you get families where people have diametrically opposed views, and an IMCA can be really helpful when there are family disagreements. They're wonderful people, IMCAs, and incredibly enabling in the process. Second is that, have you avoided making assumptions? Now, we all recognize how important this is, but this requires healthcare professionals to document that they've not based their decisions solely on an individual's age, their sex, their appearance, or their disability. And we're required to document this. Very important. Thirdly, could capacity return? So we've realized and tested that they don't have capacity, but could it come back? Now, this is important if the problem has been temporary. For example, a chest infection causing a delirium, which makes an individual lose their capacity. Now, if the answer is yes, capacity could return, and there's time, sometimes there isn't time, if there's time, then you wait to ask the individual. Now, in the example I've given of a chest infection causing a delirium, then you actually need to start antibiotics before the delirium resolves and capacity returns. So in fact, in that case, you would need to continue with this best interest checklist. Fourth, has the individual been included? Now, just because the individual lacks capacity, that does not mean that they can't be included in the discussion, at least if they're able to express an opinion. Now, what's important to realize is that the individual's opinion, this is the individual who lacks capacity, because they lack capacity, it's not legally binding on the teams caring for the individual. But as carers, we are legally bound to take it into account. So an individual's opinion, the person who lacks capacity, their opinion can't be ignored. It has to be taken into account. Fifth, is this a life-sustaining decision? Obviously, a decision around whether somebody should have cardiopulmonary resuscitation, it would be one of those. Now, this is required to ensure that death is not the only motive. It's not saying that death is a bad outcome. It's just that it's making sure that it's not the only motive for the decision. For example, it might happen if the individual had just won the lottery and others were after the money. It also requires you to be sure that no assumptions have been made about the quality of life. And the reason for this is because we know that quality of life assessments are notoriously inaccurate and open to bias. So while this seems rather a strange thing at first, it is actually a really important part of the checklist. 6, did the individual make any decision in advance when they had capacity? Now, examples of this might be an advance statement of wishes, feelings, beliefs, and values. This doesn't have to be written down, it can be verbal. Now, an advance statement is not legally binding, but as carers, we're required to take it into account. Another aspect of an advance decision is an advance decision to refuse treatment, sometimes shortened to an ADRT. Now, if it's valid, it's been correctly completed, if it's applicable to this current situation, then it is legally binding. And if somebody is refusing treatment in this, it has the same authority as somebody with capacity refusing treatment. The third thing is a health and welfare lasting power of attorney, LPA. They may or may not have an authorization for making life-sustaining decisions. Now, basically, this is where an individual with capacity gives someone else the authority to speak on their behalf. It's not giving them the authority to make the decision, but it's giving them the authority to speak on their behalf. You'd have good reasons, very good reasons for overriding an LPA. And in fact, the LPA is bound by this best interest process. Then don't act on their own, they're bound by this process. Now, you may notice what's not mentioned here are living wills and advance directives. Well, they're no longer part of the MCA. So living wills really and advance directives need to be changed into either an advance statement or an ADRT. Okay, 7th. If we're making a decision about somebody's care or treatment, have we chosen the least restrictive option? For example, if you had somebody who was very agitated, we would all agree that tying that person to the bed is a restrictive option. And what the Mental Capacity Act is saying, actually there might be less restrictive options. An example would be if the agitation is being caused by a delirium, then you could obviously want to treat the infection if that was what was causing it, and you might use some non-sedating medication to settle the agitation, because that would be a less restrictive option. 8th, have we taken into account, have we considered obligations and emotional bonds? Now, this is a requirement to view the situation from the individual's viewpoint. For example, to take into account their relationships and any obligations they have, such as returning to work. Finally, what decision would the individual have made if they had capacity? This is about walking in their shoes. It's not what decision we think is right. It's not about our personal opinions. It's not about our view of their quality of life. This is about best interests, because best interest is an estimate of the individual's viewpoint, where you balance the benefits and harms of the proposed care option. It's not what the healthcare professional thinks is best. It's not what other carers think is best. It's about everybody getting together and trying to estimate what the individual would have made of this decision. It's about empowering the individual. Thank you very much.